2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Hank Wilkins with the state, Your Honor.
Defense.
Ed Piker for Mr. Lewis.
And are you Mark Daniel Lewis?
Yes, Your Honor.
I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Mark Daniel Lewis who is placed on community supervision in 2022 CR 8453 for the offense on unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State?
Honor, violated condition number 15G, on or about the 26th day of May. And Judge, I'd like to orally amend.
Oh, just one moment. Excuse me. Could you, if you all could move to the other end. Okay. All right. Are we proceeding on the motion as presented, State?
Judge, we'd like to orally amend. I've conferred with defense counsel. We'd like to orally amend the year. It should be May 2023 instead of May 2026, Judge.
All right. Any objection?
Judge, I confer with my client on that and we have no objection.
All right. Mr. Lewis, do you understand that that's a substantive change to the motion to revoke?
Yes, Your Honor.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, Your Honor.
All right. Did you wish to proceed?
Yes, Your Honor.
All right, State.
On or about the 26th day of May 2023 in Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions.
Excuse me, just one moment. Were you changing that date?
Yes, Judge, to 26th day of May 2023.
Okay. All right. Thank you. Sorry about that.
Sorry. In Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility.
Because from the moment this hearing opens, the tone shifts fast. What looks like a routine revocation quickly turns into a procedural wildfire as the judge presses Mark Lewis on the details of his supervision and whether he understands the motion filed against him. The state immediately tries to amend the violation year, triggering a careful exchange to ensure the defendant's rights aren't steamrolled. The judge pushes for clarity, reminding Lewis he has 10 full days to prepare if he wants it. But Lewis' response, quick, steady, and surprisingly willing, keeps the momentum charged. This early tension lays the groundwork for a moment where one wrong answer could shift his entire future.
In that the defendant was behaviorally discharged from the East Texas State ISF unit in Henderson, Texas, in violation of condition number 15G.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation 15G, the court could find it true, grant the motion, sentence you to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G?
Yes, Your Honor.
Court will find violation of 15G true. Is there an agreement?
Judge, we don't necessarily have an agreement. I have no objection. The defense counsel has spoken with probation and we've conferred, and I think he has a proposal that he'd like to make to the court that the state has no objection to.
All right, Mr. Piker.
That's correct, Judge. And then I will call my client because he knows better what happened than I could ever tell you.
All right, Mr. Piker, what are you requesting?
I am requesting that the court consider keeping him on probation, not revoke him, and move him out of, don't revoke him, don't send him back to that facility and send him to lifetime recovery. We've looked into it. It's a 3-month residential. He's motivated. Actually, it was his suggestion that if that was possible to get him out of there. He wants to help. He wants to get off the drugs, but he can't do it where he's at.
Okay.
And he is going to explain that to you better than I can.
All right, Ms. Abrams.
I apologize. I cannot hear.
On this case, it is Mark Daniel Lewis. There was an incident at Henderson, and his attorney is suggesting that he be placed in inpatient at lifetime recovery.
Your Honor, probation would not have any objection.
The courtroom edges into deeper conflict as the state outlines the violation, a behavioral discharge from the treatment facility. The judge pauses repeatedly, drilling into the exact date, ensuring no detail slips through. When Lewis pleads true, the entire room tightens, because a true plea here could hand him 6 years. Yet the tension pivots unexpectedly when the defense announces they have no formal agreement, but do have a proposal the state won't oppose. Suddenly, the rigid revocation hearing becomes something else entirely. A negotiation shaped by desperation, hope, and the defense's insistence that Lewis deserves a route back into recovery rather than a return to the same environment that pushed him out.
Okay. And so that I will know, what is the issue with that facility? We'll say allegedly.
Would you like to hear it from me or from Mr. Lewis?
Either one.
Mr. Lewis can explain it better than I, but I will tell you that he was in a gang. He was in a gang when he got there. He wanted out of the gang. He told him he wanted out of the gang. His life was threatened. His well-being was threatened. And quite honestly, from what he tells me, there was so much drug usage there and fight night that it was not conducive to getting better. It made it worse.
All right. And this is at the facility in Henderson, Texas?
Yes, ma'am. He will swear, he will tell you that under oath.
Oh, no, I'm going to make sure that the facility at Henderson, Texas, that we do, that a spot check is done, random, so I can figure out what's going there, because the last thing I want is someone who's trying to get treatment and wants treatment to be sent to a facility where it's difficult to receive that.
And that's why I wanted him to address you, because I knew you'd be interested.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name.
Mark Lewis.
All right, so tell me what is going on at the Henderson facility.
Whenever I was here in this courtroom on January 13th, I signed for the 10 years probation. You gave me the choice to go receive help or go to TDC, where, so I chose the help. And whenever I was finally transported to Henderson, Texas, I threw myself into the program and I started learning about thinking errors. I started learning all the aspects I needed to learn for my first track, which was cognitive intervention, and had a very successful 45-day call. But during that time, I made the decision to step away from the gang affiliation that I was affiliated with. And
the defense steps forward with a surprising strategy, asking the court to keep Lewis on probation and reroute him to a completely different treatment program. The attorney paints a vivid picture of the Henderson facility: threats, gang pressure, zero supervision, rampant drug use, and even fight nights within the dorms. It's a stunning revelation, the kind that instantly changes the judge's posture. The courtroom hangs on every detail. Lewis tried to leave his gang, he tried to focus on recovery, and the moment he did, the environment turned hostile. Guards moved him for his safety, and when he refused to return to danger, he was labeled non-compliant. The intensity rises as the judge now must decide whether this was defiance or survival.
I made it known that they were doing fight nights. There were people out there still smoking K2.
Fight nights?
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour and they would leave until the next day. And it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter. I let everybody know, like, I was back in my Bible. I was trying to get myself right. And a lot of people took that offensive, and they threatened me, and they were trying to jump me. And thankfully the guard was able to see that something was going on, and they pulled me out of the dorm that I was in, and they placed me in a single man cell in restrictive housing. And when they came, they were like, they wanted to send me back to that environment. And I wasn't trying to go back to that environment because of the threat. And they said that by refusing that environment, I was refusing the program. And I knew that I would have to come back here and address you, but I'm trying to do better.
Okay. No, I appreciate that. So what I'll do then is I'll deny the motion and I'm going to alter and amend conditions to include lifetime recovery, the inpatient, and you'll be transferred from the jail to lifetime recovery.
Yes, Sean.
All right. Is there anything else?
That was it.
All right. We can go off the record. See what I mean about communication being key? If I don't know this is going on, then, but thank you so much for letting me know.
Thank you, Your Honor.
You didn't get any more tattoos while you were there, did
No,
you?
thankfully not.
Okay.
Thankfully not.
And he's not from Indiana.
Okay.
Okay.
All right.
All right.
Thank
Thank you, Your
you.
Honor.
Thank you for letting me know. Are you proceeding?
When Lewis finally speaks for himself, the hearing erupts with raw honesty. He describes arriving determined to change his life, diving into the program, absorbing the curriculum, pushing through 45 solid days of progress. But the chaos around him made recovery nearly impossible. Drugs circulating openly, counselors disengaged, violence simmering, and a constant threat of retaliation after he renounced his gang ties. When he explains how guards had to remove him to keep him safe, the judge's concern becomes unmistakable. Her reaction is decisive, not only acknowledging his effort but resolving to investigate the facility itself through spot checks. The power dynamic flips as the judge now presses for system accountability, not just the defendant.
On count one, waiving count two,
Yes, Judge.
any objection?
No objection.
All right, Mr. Seer, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places? Did you understand you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
There's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, he is going to work once out there. He says that he is looking to get this all behind him. And he is asking for intensive outpatient treatment if possible, because he works so many hours. I know that the TAP will show that up, Your Honor. I just wanted to add that.
All right. So what do you do other than have cocaine and meth?
I do framing and construction cleaning,
Mhm.
and I have a business, clothing business that I'm trying to get off the ground,
Mhm.
and
And you're just doing drugs on the side, part-time?
no, just being foolish, Your Honor.
How old are you?
I'm 31.
I mean, how many years are we going to take this foolishness with us?
That's and everything happens for a reason, and being here incarcerated, I never really read the Bible and stuff like that, and I found that light in me now, and I wake up more happy and everything now, I'm ready to just take my life, serious.
Yeah, what's your favorite verse in the Bible?
The Lord is my shepherd.
Oh, okay. Yeah, what verse is that?
It's Matthew.
What verse is that?
That's Psalms 23.
Okay.
The momentum peaks as Lewis lays bare the final moment that brought him back to court, refusing to re-enter the same volatile environment. His voice carries the exhaustion of someone who genuinely tried, and the judge hears it. In a striking turn, she denies the motion to revoke entirely. Instead, she alters his conditions, ordering placement into lifetime recovery, a structured inpatient program far from the chaos he described. The atmosphere shifts from tension to cautious relief. The courtroom watches as the judge emphasizes one crucial point: communication matters. If she doesn't know what's happening on the ground, she can't protect anyone. Lewis' honesty not only redirected his future but exposed failures that might affect countless others.
I'm sorry.
No problem.
It's my first time really getting into it,
Oh, no. I'm happy. Sometimes, people will always say that people find Jesus at the jail.
Yeah.
Sometimes they do, sometimes they pretend like they're doing. But I'm always interested.
Yeah.
For me, whatever helps people get through this journey we call life,
Yes.
that's a good
I
thing.
got 3 daughters and
Oh, what are their ages?
6, 7, and 8.
And who do they live with?
With both me and my girlfriend,
Mm. And who's your girlfriend?
Emily Colleen.
What were you doing with Samantha then?
That's my cousin.
So you and Samantha Servin were out with
No,
drugs.
I wasn't out with
I'm sorry, what?
nobody.
What? What is he saying?
He's saying that he was not present with anybody at the time of the arrest.
No, you were in the vehicle. What is he talking about?
That is his cousin that is mentioned in there.
All right. Is something wrong with him?
No, Your Honor. I believe that that's the only aspect that he sort of maintained was not accurate on the report. But he says everything else is accurate.
So you were not in the vehicle?
I was in the vehicle, but there's nobody with me.
Oh, so you're saying Samantha wasn't in the car with you?
I was by myself in that car.
No, they have S1 and S2.
Your Honor,
It says Based on my observations during my surveillance of the listed location and results of the traffic stop, we were able to detain S2, who was the subject of our
Just as the room settles, the hearing transitions to a second defendant, shifting into a new kind of intensity. This defendant faces a first-degree felony and admits guilt, prompting the judge to examine every detail carefully. His attorney highlights his work ethic and desire for outpatient treatment, but the judge isn't letting anything slide. She presses him about his life choices, his pattern of drug use, and even his sudden turn to faith behind bars. The conversation grows personal, pushing him to confront inconsistencies, particularly about who was with him during the arrest. His confusion raises alarms, forcing the judge to order a full psi and tap evaluation to uncover what's really happening beneath the surface.